Presentation by Miss Linda Nyamasoka. The law of evidence in the digital era is our topic for today. The law of evidence has had to adapt to the digital era as more and more evidence is now electronic in nature. This is known as electronic evidence or e-evidence. There are several challenges that rise from the use of e-evidence, including authentication, privacy, and the admissibility of this type of evidence. There have been several legal developments to try to address these challenges, and the law of evidence is constantly evolving to keep up with the technological advancements. So, to start with, we can talk about the authentication of e evidence. This is a key challenge as it can be difficult to prove that electronic evidence is what it purports to be. Authentication methods can include digital signatures, hash values, and other technical methods. Another issue is the admissibility of e evidence. Some countries have specific rules about what type of electronic evidence is admissible in court, and there is a debate about whether these rules are sufficient to ensure the integrity of e evidence. Next, we move to privacy. When dealing with e-evidence, there is a risk that the privacy of individuals could be compromised. For example, when the law enforcement agencies access electronic data, there is a risk that they could access private information that is not relevant to the investigation. And where does this lead us? This can raise concerns about the right to privacy and the protection of personal data. We move on to laws that regulate digital evidence. So there are a few different laws that regulate digital evidence, depending on the country or jurisdiction. In the United States, the Federal Rules of Evidence (FRE) govern the admissibility of digital evidence in court. The FRE have specific rules about the authentication, preservation, and discovery of electronic evidence. Other countries like the United Kingdom, have their own laws and rules for digital evidence. So different regions have different rules and regulations when it comes to digital evidence. In the United States, the Federal Rules of Evidence govern the use of digital evidence in court, and each state has its own rules as well. In the European Union, the regulation on electronic evidence in civil and commercial matters provides for rules using digital evidence in civil cases. In Asia, the rules for digital evidence vary from country to country. Within Africa, there are many different countries with different laws and rules regarding digital evidence. However, there are some common trends. Most African countries have national laws that govern electronic transactions, including the use of digital evidence in court. Many countries have also signed on to the Southern African Development Community Model Law on Electronic Transactions, which provides guidelines for the use of digital evidence. In Zimbabwe, um, digital evidence is regulated by the Electronic Transactions and Cyber Security Act of 2018. This act recognizes electronic documents as valid evidence in legal proceedings and provides rules for the authentication and preservation of such evidence. The act also addresses issues like data protection, cybercrime, and electronic commerce. The Electronic Transactions and Cyber Security Act of Zimbabwe considers digital evidence to be admissible in court as long as it meets certain requirements. For example, the evidence must be authentic and reliable and must have been obtained in a way that is fair and just. Additionally, the person producing the evidence must be able to show that it is relevant to the case. Basically, digital evidence is considered to be valid and reliable in Zimbabwe as long as it meets the requirements set out in the Act. There are several factors that are considered with determining the authenticity of digital evidence in Zimbabwe. These include the credibility of the source of evidence, including the person who created or gathered the evidence, the reliability of the technology or device used to gather the evidence, the integrity of the data itself, meaning whether it has been altered or tampered with in any way, the chain of custody, meaning the process by which the evidence was collected, stored, and handled. We are going to expand more on these. We'll start with reliability. When it comes to the reliability of digital evidence, the question is whether the evidence is what it purports to be and whether it is an accurate representation of the facts. To determine reliability, the court will look at factors such as the accuracy of the technology used to create or capture the evidence and the procedures followed in creating and storing the evidence. Additionally, the court will consider the expertise of the person who created or who gathered the evidence. If the evidence is reliable, it can be used to prove the facts of the case. There is case law to support the concept of reliability in digital evidence. We'll look at the Mutsuru and another versus Minister of Justice, Legal and Parliamentary Affairs case. In this case, the court considered the reliability of digital evidence that had been presented as part of a constitutional challenge. The court found that the evidence was reliable and ruled in favor of the plaintiffs. This case is important because it shows that even in complex legal matters involving constitutional issues, digital evidence can be considered reliable and relevant. Move on to credibility. Credibility of the source is a crucial factor in determining the reliability of digital evidence. In simple terms, credibility refers to the trustworthiness of the person or organization that created or gathered the evidence. When assessing the credibility of a source, the court will consider facts such as the qualifications and experience of the person who created the evidence and whether they have any bias or conflict of interest. For instance, if the evidence was created by a biased or untrustworthy source, it may not be considered as reliable by the court. To expand on the concept of credibility, I will use a hypothetical example. Let's say that a piece of digital evidence was created by an individual who has no expertise or training in the field and who has a history of making false claims. In this scenario, the court would likely find that the source of the evidence is not credible and that the evidence would be considered unreliable. In contrast, if the same piece of evidence was created by a qualified expert with no conflict of interest, the court would likely to find the source credible and the evidence would be considered reliable. A relevant case is the matter of State versus Makwanyane. In this case, the court considered the issue of credibility in relation to a voice recording that was presented as evidence. The court found that the source of the recording was not credible, and therefore the evidence was inadmissible. This case shows that even when the digital evidence itself is of a high quality, it must still be presented by a credible source in order to be considered reliable. Next, we move on to integrity. The integrity of the data refers to the reliability and accuracy of the data itself. In other words, it is important to ensure that the data has not been altered, deleted, or otherwise compromised in any way. There are several ways to assess the integrity of digital evidence, including digital forensic analysis and checksum validation. It is also important to consider the context of the data and how it was created and stored. I'll make use of another hypothetical scenario to illustrate the concept of integrity. In an instance where a police officer is investigating a crime and they find a piece of digital evidence on the suspect's computer, the evidence appears to be a video recording of the crime, but the officer has no way to verify whether the video is authentic or whether it has been altered in any way. In this scenario, the integrity of the data is questionable, and the officer will need to perform further analysis to determine whether the evidence is reliable. There are several cases that have considered the issue of integrity in relation to digital evidence. For example, in the case of State versus Joan, the state found that the evidence in question was a digital image that had been edited, and therefore its integrity was compromised. In reaching this decision, the court relied on expert evidence from a digital forensic analyst who explained that the editing of the image had introduced doubt as to its reliability and accuracy. The court concluded that it was not possible to determine whether the original image was an accurate representation of the crime scene, and therefore the evidence was inadmissible. Lastly, we'll move on to the chain of custody. The chain of custody refers to the process by which evidence is collected, stored, and handled. It is important to maintain a clear chain of custody as it helps to ensure the integrity of the evidence and prevent it from being compromised. The chain of custody is typically documented, and all individuals who have handled the evidence should be identified. Any breaks in the chain of custody can call into question the integrity of the evidence. A break in the chain of custody can occur when there is a gap in the documentation of how the evidence was handled, or when the evidence is not properly stored or secured. For example, if a piece of evidence is not properly sealed or labeled, or if it is not stored in a secure location, this can be considered a break in the chain of custody. Even if the evidence itself has not been tampered with, a break in the chain of custody can cast doubt on its authenticity. I'll talk about the advantages of digital evidence in Zimbabwe. In Zimbabwe, there are several advantages of using digital evidence in the judicial system. First, digital evidence can be more reliable than other forms of evidence, such as witness testimony. This is because digital evidence can be easily verified and can be analyzed by experts to determine its authenticity. Second, digital evidence can be more easily preserved than other types of evidence. For example, digital evidence can be backed up and stored securely, whilst physical evidence can be damaged or lost over time. Finally, digital evidence can be more cost effective than other forms of evidence. Let's move on to the disadvantages of digital evidence in Zimbabwe. One of the main disadvantages of digital evidence in Zimbabwe is the lack of infrastructure to support its use. Many parts of the country have poor internet connectivity, making it difficult to access and analyze digital evidence. In addition, there is a lack of trained personnel who can collect and analyze digital evidence. This lack of expertise can lead to errors in the collection and analysis of digital evidence, which can compromise the integrity of the evidence. Another disadvantage of using digital evidence in Zimbabwe is that it can be difficult to authenticate. In order for digital evidence to be admissible in court, it must be shown to be authentic and unaltered. However, it can be difficult to authenticate digital evidence, especially if the evidence has been stored on a device that can be easily altered or if the chain of custody has been broken. This can lead to questions about the accuracy and reliability of the evidence, which can make it difficult to use in. So, to conclude, digital evidence can be valuable and can help to solve crimes effectively. However, there are also a number of challenges associated with the use of digital evidence, including issues around reliability, integrity, and chain of custody. There are also ethical concerns around the collection and use of digital evidence in Zimbabwe. This is the end of our presentation today.